So much damage has been done by people's ignorance. So much damage has been done by good-hearted people who intend to free themselves. And in the process of that, they go along with a trend arbitrarily, blindly, without cross-reference to the truth or fact, or without deep comprehension of the dynamics of how things work. As a result of that, they suffer and set the path for others to suffer. I'm going to show you separate res judicatas of people hanging on to suppositions that you will publicly find in abundance on the internet that has led to stare decisis being created on appeal level. A lot of people speak of common law as judge-made law, right? Okay. Here's one of those judge-made law, aka common law, that you all love so much, that you all hang on to so much, contradicting the same other principles that you all hold on to. The majority of these people that are involved in this case truly intend to do something good, but they fell victim to others' hype train, to others' misinformation. Misinformation creates way more damage than lack of information, because with misinformation, the party that's received that misinformation accepts it as though they know what's going on, and so they carry it on with the will of fire and spread that misinformation. Someone on the other hand who doesn't know at all does not really have any predisposed state of mind about one thing or the other, and thus they are usually apprehensive before they act, or in some case they do not act at all. Here is the damage that has been caused by people reading some stuff on some website, by people reading PDFs after PDF, by people following some SPC, sovereign citizen, or some other cliche, hype train, and emotionally stimulating stuff. In the past videos, we've went into the details of preponderance of evidence, what it means, and the fact that your mere narration of fact is not admissible as evidence. And then the other part 2 of the video, we went over what constitutes an affidavit, the 6 separate elements of what constitutes affidavit, according to American jurisprudence and res judicata, aka that judge-made law that everyone loves so much. These are 101s. These are not even the norm of how things are to be enforced to get remedy. These are not even 0.0. This is still damage control being done. This is still in the negative. This is not even the beginning point of how to learn to do something. But on the other hand, it nonetheless is, because people have been pulled back so much with so much misinformation. The damage control first has to be done to wash people's minds off of that misinformation so we can get to 0.0 to begin to do things. There are way more other things of this nature that it is so embarrassing that I cannot even show in a public venue. But people need to know this truth, because a lot of people are coming into these informations and they are running into it head on. They find the next PDF. They ask someone, what can I read? What template can I use? And people just throw it to them with zeal. The people throwing it to them with zeal and passion haven't used it themselves successfully, and don't know about it, haven't read it, and haven't cross-referenced it in any way, shape, or form, beyond merely regurgitating a repetition. The subject matter of today is affidavit of truth and affidavit of fact. I deliberately created 2 videos first dedicated to the clarity of what an affidavit is, and how it relates to preponderance and admissible evidence, in conjunction with all the other types of videos done with hearsays, what is self-authenticating evidence, the 19 types of objections, the basics of the uniformative evidence, all those things. Here's another clarity, because most people, when they do things, they highly rely on affidavit of truth and affidavit of fact and presume that to be the end-all, meet-all, checkmate. Here is a preponderance of evidence that I'm showing you that your affidavit of fact and affidavit of truth, beyond what you think an affidavit is dead, and that a lot of people have used it in the past to their detriment, and to the detriment of you watching this, to the detriment of the children that will become in the future. Because these are res judicata's on appeal level. Appeal makes the final determination of judge-made laws. And based on full faith and credit in Article 4 of the Articles of Confederation, and Article 4, Section 1 of the United States Constitution, and then within your state constitutions also, all this is fully enforceable. The first case law, Capenda versus Parker, Court of Appeal of Ohio, 10th Appeal District. In this case, appellant discusses his appearance at the hearing before the trial court magistrate on April 9, 2018. This is not a hearing or court case that took place in 18-something that might have been overturned. This is 2022 we're at. This was just 4 years ago. This is very recent, and this is on an appeal level. On April 9, 2018, and argues that his submittal of unrebutted affidavit stands as truth in commerce. Who brought up this phrase? Where did this phrase come from? When you begin to do research on affidavit and things of this nature, and you start to read all these PDFs, you will see this phrase everywhere. Yet, when you read books based on maxims that were adopted from Latin, that were adopted from other things like Arabic, that were adopted from other ancient principles, whether it be from American jurisprudence or English jurisprudence, or other type of laws homogenized here in North America, you will never, ever find this phrase, unrebutted affidavit stands as truth in commerce. You know who made up this phrase? The same guy who made up the whole acceptance of value and conditional acceptance, whose court case showed that whatever it is that he was doing could not help him because he was issuing promissory note. And when they charged him with fictitious obligation and some more, he attempted to use all this and did not work. And no one that's been using all these other methods such as acceptance of value and conditional acceptance cannot show that it has worked. And in the past, we have shown the true aspect within the Uniform Commercial Code of what people presume to be accepted for value and conditional acceptance, which is conditional subsequence and condition precedent. There are videos done on that. Here is another misconception that's been put out there. A lot of people use this phrase, unrebutted affidavit stands as truth in commerce. Where did this come from? Why does no one question its origin or its validity or cross-reference it with any substance? These same people that will tell you that judge-made law is common law will fail to cross-reference these phrases and these terminologies and these methods that they're using. Do you see the hypocrisy? On April 9, 2018, appellant discussed and argued his submittal of unrebutted affidavit stands as truth in commerce. They made reference to the brief, document number 11. And by the way, once more, this is the name of the case and this is the court, so you can cross-reference this yourself. Appellant contends appellee failed to present alleged signed contract subjecting appellant to the jurisdiction, rules, statutes, and state codes, and that appellee, the one being appealed against, signed up without authority and committed fraud. We've went over this on Patreon. What fraud means, people don't know. The different types of fraud, people don't know. How fraud is invoked, people don't know. How to align fraud into your case, people don't know. The elements and tests involved in fraud, people do not know. These nuances will not be told to you by the acting judges that you need to prove it or show it, because it's already been said in other res judicata's. And now you bring some other spurious stuff that does not exist and you're trying to compel it as a form of performance. No, that's delusion. And you're making it worse for yourself and everyone else. If truly you care for freedom, you will not just be arbitrarily accepting what other people tell you without reference, without common sense explanation, without detailed explanation, with reference and examples, beyond just piling up PDFs and accumulating information. Just as one accumulates technological luxury in today's world, you see technology everywhere, phones everywhere, Bluetooth everywhere. That technological luxury is not synonymous with technological advancement. The same applies with information. The luxury of accumulating a lot of information is not synonymous with advancement of knowledge, wisdom, or even more important, the functional aspect of knowledge and wisdom to make your life better, to get these people off of you. You say you're sovereign. You say you're more, you're this and that. Nothing wrong with those claims. Make those claims. But know what you're talking about and stop making it worse for yourself and everyone else. Appellant further asserts that appellee and the magistrate denationalize him by not acknowledging him to be who he and his documentation says he is, and that he was discriminated against because of his religion. What are the elements of that religious rights and test involved for him to invoke or evoke? He's not doing it. He's not claiming undue burden. If you're not claiming undue burden when it comes to religious rights or constitutional rights, it's deemed as though it never existed. What are the preponderance of evidence that you were denationalized beyond your mere speculation and citation? Appellant asserts his constitutional rights were violated regarding imprisonment for debt and the suspension of his driver's license. This tool is not yours. Contract law lets you know it's not yours. And if you're being imprisoned for debt, where's the proof? Appellant argues he was not able to travel freely as free national man, free of bondage to a federal corporation he is not a part of. Instead, he was treated as if he was under the control of unconstitutional law. Appellant additionally contends he could not support his family because whatever the entity was removed his barber license in addition to the driver's license and extorted him in violation of federal racketeering and extortion laws. These racketeering and federal extortion laws, if you know its origin and how it deals with drug dealing and insider private interests, you would know that this is not even where it's at. This racketeering and extortion law is not meant for you to use. It does not assist you with private right of action. Just read the intent of Congress when they created these laws. It's that simple. You're making a claim about barber license. That's their tool. You should know this if you claim it to be a national. However, appellant has not addressed why the Attorney General's liability to make an investigative demand for discovery under rule so-and-so in the antitrust setting applies and demands reversal of this case. No preponderance of evidence. Private interest, intent of the Congress when it comes to racketeering and extortion law. They're telling you antitrust law. That's why racketeering and extortion laws were created. He doesn't even know this. Appellant likewise does not address or provide legal authority specific to the hearing on his objection or the trial court's subsequent dismissal of his objection. You're not providing any law into the matter. Legal means operation of law. If you cannot even provide the law, how can you even enforce it in the first place? This guy, he's just using buzzwords. No law involved, no operation of it. You know what these legal authority means? The doctrines, the tests, the elements, and the foundational principle behind the rights that he's saying he's enforcing, or that was abrogated. Appellant Appellant likewise does not address or provide legal authority specific to the hearing on his objection or the trial court's subsequent dismissal of his objection. Considering all the above and addressing the error assigned, we conclude appellant has not met his burden in affirmatively demonstrating error on appeal. Conclusion. Having overruled appellant's sole assignment of error, we affirm the judgment of the Frank County Court of Common Pleas. You know how hard it is for appeal cases to be accepted? Only a very small amount of appeal cases are ever accepted. This guy finally got his appeal accepted, and he just botched it. He screwed it up. And now this is a res judicata. And guess what? An attorney will use this against you. That this thing has already been thrown to the side, making these claims, because there's no legal authority behind it. They're going to pick and choose these specific parts because it does align with the totality of the intent of the appellant as to how some error was created. That's the first case law. The second case law, Bay versus Stumpf, United States District Court, New Jersey, October 17, 2011. You can cross-reference this yourself. On January 24, 2011, and written in nature of discovery and disclosure of all contracts and adhesion allonges was sent to the above listed individuals regarding a loan which is in controversy. On February 17, 2011, and notice of default was sent to the above listed individuals regarding dishonor due to incomplete, non-germane information provided in regards to discovery and disclosure. On March 10, 2011, and second notice of default was sent to the above listed individuals regarding dishonor due to incomplete, non-germane information provided regarding the notice of default. So in the mind of this man or woman, they're doing a so-called administrative process or notarial protest. In the past, we've went over the foundation of why it works and why it doesn't work and the right way to do it. In the future, we'll be going over the details, most likely not on YouTube. On April 1, 2011, an affidavit of fact, there we go, notice of default judgment and compensatory invoice for expenditure was sent to the above listed individual regarding dishonor due to incomplete, non-germane information provided in regard to second notice of default. On April 18, 2011, and a reconveyance was sent to above list individuals regarding dishonor due to non-response in regard to the unassigned, unidentified mortgage and election to sell under deed of trust. So this man or woman has put his property in jeopardy. One of the basic things humans need to sustain a good state of mind, a shelter. Granted, a shelter doesn't have to be the box we perceive as a house. But nonetheless, this man or woman is putting in line one of their way of life with some speculation that I'm quite certain someone approached them valiantly, zealously, passionately, and very confidently, and they just ate it up. And that fire of misinformation was held and carried by them confidently. They ran with it. They raised their hands up with that fire of misinformation. And that fire of misinformation turned to misfortune and overtook them. I'm sharing this so that you don't make the same mistakes. The dynamics of how things work is important beyond buzzwords. This misinformation has been going on for too long. It makes no sense that people's lives are being screwed up because of misinformation. And the people on the other end that we all purport to want to free ourselves from, they're happy this is going on. They're joyful this is going on. This is perfect for them. So in the process of supposedly freeing yourself, you are assisting them perpetuate the will of serfdom. Why? Because you fail to do due diligence, to self-reflect, to read, to go beyond buzzwords. This is the reason why this page was created, to inform people properly and to show people the subtleties and things that they miss that's screwing them up and that is screwing the future up. The defendant have failed to cease collection activity until timely disclosure and validation of the debt. Therefore, default judgment was applied pursuant to the following maxim of law. In addition, a quitclaim transfer of inheritance, and I'll say saying in the deed regarding latitude, longitude, so-and-so, and the postal address was also filed in the public record with the Federal District Court of New York, United Nations, International Criminal Court, International Court of Justice, the Federal Bureau of Investigation, New Jersey, Philadelphia, Pennsylvania, and Washington, D.C., United States Justice Department, United States Department of State, and was also publicly published. And then they go and list the documents. In commerce, truth is sovereign. Truth is expressed in the form of an affidavit. An unrebutted affidavit stands as truth in commerce. An unrebutted affidavit becomes a judgment in commerce. He who leaves the battlefield first loses by default. You know who came up with all this? The same man who came up with a accepted for value and conditional acceptance. The following has been initiated based on supreme law of the land, United States Republic Constitution, treaty, the Declaration by United Nations, and the Vienna Convention. Now they're taking other bodies of instrument in an attempt to mix and match to validate speculation. This is where the fuckery lies. You take something that is completely dead, speculative, unsubstantiated, and you take something else that appears to maybe will assist you somehow, and then you just mix and match it and hope to just hark and bark at someone that it works. That's called delusion. We have to be honest with each other and speak to each other in a very straightforward and forthcoming manner like this. For us to comprehend that misinformation has been dominant among many people who purport to want to free themselves. And that misinformation is harming them now, has been harming them in the past, and will perpetuate itself to their detriment and their children's detriment in the future. It has to stop. In light of the above quoted content in the pleading, the court cannot rule out the possibility that plaintiff did not, meaning we cannot overlook the fact that plaintiff did not commence this matter with a bona fide litigation in mind. In light of the above quoted content of the pleading, this court cannot rule out the possibility that plaintiff did not commence this matter with a bona fide litigation in mind. Meaning there's a deficiency in the man's state of mind doing all this. Indeed, the content of the pleading suggests that plaintiff might be attempting to capitalize on the docketing system of federal courts in general. Meaning he's just attempting to now use some form of record just to do one thing or the other without any fixed aspect of law or the operation of laws to substantiate it. And this district in particular, in order to A, assert the pleading is unfiled quote with the district, and then B, build on this fact by self-declaring their right to a certain real estate property, and by claiming that this property is free from mortgage encumbrance held similarly by the Wells Fargo so-and-so. If plaintiff's submission meant to be a complaint, it is defective. However, at this juncture, the court cannot also rule out the possibility that this gibberish-filled 18-page single-space pleading was submitted by plaintiff as a result of their good faith reliance on a hoax source. Meaning, we feel for you, bro. You've been got. All that passion you have, all those 18 pages of you saying nothing, we don't blame you. The source of where you're getting it from is just hyping you up without showing you any law, any substance to it, or any reference to why it works, how it works, or how it has worked, which misled plaintiffs into believing that the pleading could operate as a valid civil complaint. In other words, your pen and paper game is weak, and we get it. It's because you've been misled, you've been misinformed. The court therefore finds it warranted to provide plaintiffs with guidance, meaning, you know what, we'll now afford you due process. We see your intent is good. We see that there might be some validity in where you're going, but you've been misled. So we'll give you an opportunity to fix it by telling you that you've been misled. So as much as people might want to say this guy's a fraud, they're bad, some of them actually afford you due process. Don't get me wrong. There are assholes out there. And there are some who think because they belong to some order or organization, they're special, despite them not knowing the true meaning of the handshakes and the secret words and the significance and the functional aspect of it. They just belong to some lodge, so they feel good. They have this job, so they feel like God and want to play God. And usually those types on the other side would not do this. You can tell this is an honorable man or honorable woman, actually guiding that lost soul into the right direction. So kudos to the acting judge that did this. They could have just shunned him or her and not even give any explanation. They could have just gave a little bit of explanation, made it more vague, and then shut the whole thing down and say, get out of our face. Instead, they provided plaintiffs with guidance as to the requirement applicable to a civil complaint and will direct clerk to serve plaintiffs with a court-approved blank civil complaint form. We went over the power of this also. Don't fill out their form, don't fill out their forms. Yeah, we know. But there's a reason why everything exists, and it's how you do it that matters. So plaintiffs would have an opportunity to cure the deficiencies of their current pleading by submitting a meaningful amended complaint. Then they then go over the elements of what a complaint constitutes. Meaning we're now going to take you back to school and help you out. A civil complaint must be a clear and concise statement. They go over all the details. Here the pleading is neither short nor plain. It's vague, long-winded, and pointless, is what they're saying. And it shows, if anything, that plaintiffs are not entitled to relief, and therefore you're long-winded, you're not to the point. What you're talking about is unsubstantiated. You're just throwing a bunch of buzzwords and a bunch of personal feelings on a piece of paper, so you fail to state a claim upon which relief can be granted. Therefore, the pleading will be dismissed without prejudice. To be dismissed with prejudice means you can't bring this trash back in here. Without prejudice, to be dismissed without prejudice means we're going to throw it out, but look, you can still come back if you can fix the error. There are two types of defective errors when it comes to general pleadings. There are just normal defective errors, and then there are fatal defective errors. This man or woman who is the acting judge is saying this error that you have made is not fatal because as part of an affirmative defense, one of the affirmative defense is actually lack of knowledge. And they're saying, okay, you lack the knowledge of certain things, so we got you. We'll help you out. We'll explain where you went wrong, where the error was, and here's the solution. Then they went on the other deficiency, and it relies on the Barbary treaties in general, or in the treaty with Morocco in particular, is facially frivolous. This is true. Another video will be done in the future as to why using a treaty of peace of friendship that a lot of people go on about, especially Moors, why it's actually wrong to use that. We'll go over that in the future. And where it started for people to start using it and why they think it's been substantiated, who knows? Here, plaintiff's pleading repeatedly asserts that plaintiff have certain rights with regards to certain real estate property, meaning birthright inheritance, which is not wrong. See, the underlying factor is not wrong, but how it's enforced and the competence behind it is the issue. From this reference, the court gathers that plaintiff is referring to a treaty with Morocco. However, meaning automatically you haven't even brought in admissible evidence that this landmass called North America is Morocco. You haven't brought in any ancient record. And then once you prove that this landmass is Morocco, prove that you are a direct lineage of one of those people tied to that landmass. And the only way you can do that is show the form of government that was tied to that thing called Morocco. And guess what? They know about it because they're all Masons. The question is, do you? As this court already explained in the Murakush Maxim, a litigant's reliance on a Barbary treaty, including on the Treaty of Morocco, for the purposes of a civil suit, raising claims based on events that occurred within what the United States geographical territory, is facially frivolous. To give you the reference. And that includes any claims related to real estate property located within the United States. They're telling you the presumption here is that this shit is under our jurisdiction, our corporate body politic. Just show that it's not part of it, and maybe you'll be able to state a claim. Collection of mortgage payments, foreclosure, eviction proceedings. Then he gave more reference. As its title indicates, the treaty is one of peace and friendship between the sovereign states of Morocco and the United States, and it provides that subjects or citizens of each country will be held safe by the other. See, most people who use a treaty of peace and friendship don't even read the verbiage of the articles. They don't cross-reference the intent behind each article and each sections. They don't cross-reference the event that led to each articles and each sections. They don't cross-reference to where it was signed, who the signatories are, why it was signed, what led up to it, and where it applies at. They just loosely heard that Al-Maghrib Al-Aqsa is the farthest west, and in the ancient world that's called Al-Morocco, and Al-Morocco is the same thing as Morocco, and the western part of the world is Morocco. Yet these same people will tell you that the maps have been orientated from east to west. So east used to be west and west used to be east. So now what we look into the map as west is really east, but they're also claiming that the farthest west is here. Pure contradiction. And even if that was not the case with the orientation of the map, where's the preponderance of evidence of all that? Beyond speculation. Where's the preponderance of evidence? Rule 901, authenticating and identifying evidence, tells you about ancient documents, evidence about ancient document or data compilation. Rule 803, exceptions to the rule against hearsay, tell you about ancient documents, statements in ancient document. Are they using any of these rules of evidence? No, they're not. You see the problem and the issue in all these things? And it provides the subject or citizens of each country will be held safe by the other, as well as a protocol of any confrontation that might arise between the two countries while at sea, during trade or battle. It does not contain any language suggesting that the United States or any state or territory therein does not have jurisdiction over a person violating the law within its jurisdiction. United States, that is. Dismissing claims by a Moorish litigant that the aforementioned indigenous real private property is now free from encumbrance and is now and forever exempt from levy. Now you're taking some title and some name and some term, and you're tarnishing it. You're creating an expectation and a res judicata that anyone else who comes in under certain claims should now just be railroaded because of your previous lack of due diligence. Here are plaintiffs named as defendant in this action: John Stumps and spouse. Like Charlie Sprinkle. Like Charlie Sprinkle did in the suit. A lot of people jump on that guy's nuts too in that case law. Oh, he mentioned the governor and his spouse. I'm going to do the same thing. Look, there's preponderance of evidence involved in that. There are elements of being able to prove personal involvement for you to do all that. There are doctrines that govern all that also. The reason why Charlie Sprinkle's case was settled in his favor in a private were a lot more underlying things that were never revealed in the public. It was more than the actual suit itself. That guy, Charlie Sprinkle, he was a high-level Mason, and he had some other stuff going on with them on the inside. That you wouldn't hear about. That was the true intent and motivating factor behind all that. And if you really read the court order, the mere fact that the spouse of the governor and all that were sued is not the reason why the case was settled in the private, which caused them to dismiss it in the public. Read these things before you jump into it and try to mimic it. Here, plaintiff named as defendant in this action: John Stumpf and spouse, Mark C. Ullman and spouse, Nicole Hackett and spouse, so on and so forth. Plaintiff cannot assert viable claims against Stumpf and Ullman merely on the basis of their supervisory positions, just as plaintiff cannot assert viable claims against Hackett, Gitcher, and Brown without stating the facts showing that Hackett, Gitcher, and Brown were personally involved in alleged wrong. Plaintiff cannot assert claims against this defendant, hypothetically existing spouse, in the mere basis of these spouses' marital ties. You have to show interest. You have to show how pecuniary interest was gained, or somehow how they benefited from the damage that they created to you, presuming you even know how to bring the damage and the preponderance of evidence of the damage in the first place. They're saying, you know what, we'll give you a chance. Thus, in the event plaintiffs elect to submit an amended pleading, plaintiffs shall detail clearly and concisely the facts showing each defendant's involvement in each wrong. They're giving him the elements of what he needs to do to actually state a claim. Meaning, you know what, this is what you're saying you want to do, here, we'll help you out. Here it is. We're not saying here, look, there are other things you have to do, but based on what you're trying to do, here. Each plaintiff must have standing to sue. Conclusion: for the foregoing reasons, plaintiff will be denied informer pauper status. Such denial will be without prejudice to seeking informer pauper status by submitting each plaintiff's duly executed court approves application form. Meaning this was the beginning portion of the whole thing. And they just said, look, we're not going to deal with this, but we'll give you an opportunity. The submission docketed as docket entry number 1 will be deemed stricken from the docket for any purpose other than initiation of bona fide litigation. The clerk will be directed to clarify the mere fact of the submission being entered on the docket of this district cannot be construed or otherwise used as evidence of or as a fact confirmed directly by implication, estoppel, or otherwise any license, property, or any other right upon plaintiff. An alternative, the submission docket as docket entry number 1 will be dismissed without prejudice to plaintiff's timely filing of a clear and concise amended complaint executed in strict compliance with the guidance provided to plaintiff's hearing. That's the second case. Relying on all these catchphrases, these buzzwords, it's going to do you nothing. Know what you're actually doing. Know the dynamics. And that's just the second case. Here's a third one. Bryant versus Washington MUT Bank. Because defendant did not respond to any of her affidavits, plaintiff argued that they are now estopped from disputing the truth of her claim. Yet plaintiff's citation for his proposition are at best only tangentially related to her estoppel claims and certainly provides no support for it, as enacted in Virginia Uniform Commercial Code states that conditions are which a person gives value for right acquired. Define documents of title. They give you all the reference. They throw the actual Uniform Commercial Codes at you. None of these provisions suggest that failure to respond to an, quote, affidavit of truth within 10 days constitute an admission that it stops one from later disputing the assertion of the affidavit. Indeed, they do not even suggest the defendant had any legal obligation. See what I'm saying? It compels no performance. Had no legal obligation to respond to plaintiff's affidavits at all, or that plaintiff can create such an obligation simply by stating in a document that the obligations exist and having the document notarized. You merely narrating something does not create or compel performance. It doesn't work like that. Plaintiffs assert that the court is bound by a variety of maxims of law, in quotes. These are not even maxims of law. such as an unrebutted affidavit stands as truth in commerce. An unrebutted affidavit becomes judgment in commerce. Although some of these, quote, maxims not related to unrebutted affidavits may generally reflect valid legal principles, plaintiffs offer no authority for the proposition that any of them have the force of binding law. This speaks for itself. Conclusion. For the foregoing reasons, defendant's amended motion to dismiss plaintiff's second amended complaint will be granted. They dismiss the case. That's the third one. Capenda versus Parker. The fourth one, Black versus Van Sciver, United States District Court of the Eastern District. Plaintiff, who is proceeding pro se, filed this action on June 17, 2016. Another recent case. You wonder why they give pro se litigants a hard time? Because a lot of people have been going gung-ho doing things that are unsubstantiated, based on buzzwords and a feel of misinformation, a passion of misinformation. They fell for the trap because in the process of you attempting to free yourself, if someone can put a misinformation there, they can easily ward you off into some other lawless land. And they've successfully averted you from even doing anything to free yourself. Because they know you are so determined to free yourself that even if you're given misinformation, you will hold on to it so tight and you will not let it go. Black versus Van Sciver. Finally, plaintiffs assert that one of the exhibits submitted with his complaint is his affidavit of truth. Here we go, which has been defaulted by proof of file stamped by the clerk of the court. Plaintiff asks, is it not true that all men are equal under the law? The truth is expressed in form of an affidavit, and that an unrebutted affidavit stands as truth in commerce. An unrebutted affidavit becomes judgment in commerce. Is it not true that Kirk Davis, blah blah blah, has interfered with commerce? Where in the world? Where did they get this from? Winston Shrout, the guy who created acceptance for value and conditional acceptance. How did it end? Conclusion. Plaintiffs claim under APA and the cited federal criminal statutes, we went over the flaws with this also regarding people citing criminal statutes, are wholly insubstantial and frivolous. No substance, and it's a waste of time. It's just a bunch of paper that's causing us headache. They give it a reference. It is clear that the court does not have subject matter jurisdiction over plaintiff's claim as presented in his original complaint. Then, yeah, you know what, you're right. We don't have any jurisdiction over all this trash. Accordingly, defendant Van Sciver's motion to dismiss is granted, and the complaint is dismissed as to all defendants without prejudice and with leave to amend. 2. If plaintiff elects to pursue this action, he shall file an amended complaint within 21 days of the date of this order. 21 days is a standard period of response for pleading on a federal level. So they're even as kind enough to afford him due process. 3rd, plaintiff failure to file an amended complaint within a time period will result in this dismissal of this action. September 1, 2016. There's the 4th one. The 5th one, Chiba versus First FIN Asset MGMN Inc., United States District Court of Southern District. The plaintiff claimed defendant did not rebut their affidavit with an affidavit, and that unrebutted affidavit stands as truth. The same crap again. However, as noted above, the party is permitted to raise an evidentiary objection, meaning evidence, rule of evidence, objection, the 19 types of objections, to the evidence offered by the opposing party. Defendant did not seek to enter conflicting evidence. It merely pointed to alleged evidentiary problems in the plaintiff's affidavit, meaning there's no evidence. The motion to strike is therefore denied. How did this end? Summary judgment is therefore granted. So you're seeing now that on all ends, all this unrebutted affidavit stands as truth, the law and commerce, this and that, all that stuff is just speculation. Not one man can show you the substance behind it beyond speculation. Besides not even knowing what an affidavit is, besides not knowing the difference between the mere narration of fact, which is presuming you actually did a proper affidavit, versus evidence, let alone admissible evidence. That's the fifth one. This is the sixth one. Atkins versus Kentucky, United States District Court, Western District. The filing discusses an affidavit which petitioner apparently signed. It states, truth as a valid statement of reality is sovereign in commerce. Where did this come in? This is created by some guy. An unrebutted affidavit or declaration stands as truth in commerce. Here we go again, regurgitation of the same thing. An unrebutted affidavit is acted upon as a judgment in commerce. Come on now. Commerce has its own delineation of what's needed and what is not. And it's based on the specific types of contracts and the matters that you deal with. Not just some blanket stuff that you just throw to everyone and slap everyone with it and hope someone just performs on it. They go on to say the only claim for relief the court can discern in this filing is petitioner's statement as follows. As one of we the people, I do hereby politely and with honor command you, our public servants, to follow mandates, directives, and one, dismiss the cancel the illegitimate trial scheduled for 13th day of December 2018, dismissal all charges with extreme prejudice, eliminate the record, and avoid ab initio. Only constitutional claims were verified or recognized. This is a 2018 case, docket number 3:18-MC-26-DJH. For your reference. That's the title. To another one. Here's the seventh one. Yuska versus Iowa DEPT of Revenue. United States Bankruptcy Court, ND, Iowa, July 6, 2016. David also filed an affidavit asserting that he does not owe Iowa income tax. David asserts that an unrebutted affidavit stands as truth, meaning, well, I did an affidavit. Ha! I did what I thought was an affidavit. I got you now. You must rebut it. Otherwise, I don't owe you tax. Whether Davis owes Iowa tax is a legal question that cannot be answered without reference to Iowa law. A question of fact can be answered solely by determining the fact of a case, without any need to know the law relevant to the case. A question of law can be answered solely by determining what relevant law means, without any need to determine the fact of a case. David's affidavit asserting that he does not owe Iowa income tax does not state any fact, even though he's saying he did an affidavit of truth or an affidavit of fact. They're letting you know that your affidavit does not constitute a fact and is not admissible. David's affidavit asserting that he does not owe Iowa income tax does not state any fact, meaning you have to deal with the specific matters, the laws, the right involved with a specific instant matter, not just some blanket stuff you heard somewhere that's unsubstantiated. That is the issue with people. As a result, it is insufficient to defeat IDOR's motion for summary judgment. Unsupported allegations or affidavits setting forth ultimate or conclusory facts or conclusions of law are insufficient to either support or defeat a motion for summary judgment. They shut that down. Conclusion. IDOR's motion for summary judgment granted. Here's the eighth case. Bank of New York versus John Osiris, United States District Court, ND, Illinois. It's in division. Docket number 09C6405. Do you see the consistency on the buzzwords and the issues that people find online and they just run with? This one is specific to someone trying to use a tracer flag. The notation, a security, 15 USC, is a flag in commerce telling the US SEC that a speculation account is being established to enforce a lien. The US SEC can then monitor the process. As long as the process is truthful, open and above board, full disclosure, and in good faith, principles of contract, the US SEC has no jurisdiction over it. For even the US SEC has no jurisdiction over the truth of testimony, depositions, affidavits, and affidavits of obligation, commercial liens, and an unrebutted affidavit stands as truth in commerce. Legal authority, universal moral existential truth principle expressed in Judaic Mosaic Orthodox Hebrew Jewish Commercial Code, corollary to Exodus, chiefly Exodus 20:15-16. This is the best known commercial process in America. This is what they heard from someone. When an affidavit is so flagged in commerce, it becomes a federal document because it could become translated into a security, for example, by being attached in support of a commercial lien and not accepting or filing a commercial affidavit becomes a federal offense. The hype being regurgitated. Now this is their response. A complaint not expressly pleading a federal question may be removed when the claims implicate significant federal issue. You know what their response is? Since none frivolous basis for removal of jurisdiction is stated, the motion for proceeding in form of frivolous will be denied, and this case will be remanded to state court. The clerk of court will be directed to wait until November 20, 2009 to remand this case. If John desires to seek reconsideration of the remand, he must move for reconsideration by no later than November 13, 2009. It is therefore ordered that the clerk of court is directed to amend the docket A to reflect that the name of the defendant, John Osiris, is actually John Osiris of the family Jones L, and B to list John Woodward and J. Jones L as defendant. John Osiris' motion to proceed in the form of purpose is denied. The clerk of court is further directed to remand this case to the Circuit Court of Cook County, Illinois, County Department, Chancery Division. Remand in this case stayed until November 2nd, 2009. And then whatever it is you bring you here, man, just take it back where you're coming from. All that stuff is inapplicable here. That is the 8th one. Here's the 9th one. Sandiford versus J.P. Morgan Chase Bank, United States District Court, Middle District of Florida. Docket number 3:21-CV-313-TJC-LLL. Sandiford filed an opposition to defendant's motion to dismiss, meaning he brought a claim, and then of course a motion to dismiss is really the only tool that's required to really throw away a complaint if your complaint is not on point, which the court treats as a response. Of course, it's a responsive pleading. The response argues that she filed her complaint within 1 year of an affidavit in January 2021. So now this affidavit is the sole reliance of everything within the complaint. Not a smart thing to do. Requires that a finance charge be the sum of all charges, she argues, and therefore collection of repayment for the credit that Chase extended to her was fraudulent. Why aren't you using National Bank Act? Why aren't you using the fact that the bank doesn't even have any asset to lend out in the first place? Instead, you're doing some speculative stuff somewhere. People divert their solutions by their own doing. Why? Because of misinformation and the passion and zeal to which it's presented to them. They see the passion, the zeal. They feel good, like, yeah, let's go. But they're carrying around misinformation. And they lose the opportunity to learn something new and actually truly save themselves from the immediate danger that's going on. They lose things that are valuable to them, beginning with the time, the energy, the effort, and then the assets that they've worked hard for someone else for, just to gain that little bit of amount. Just to lose it because somebody came to you with a lot of passion and zeal with some trash misinformation. She argues that an unrebutted / uncontested affidavit stands as truth, and that Chase has failed to rebut her affidavit with its own affidavit. The response filed, despite plaintiff's motion being substantially and procedurally improper, points out that there is simply no plausible legal claims or arguments that Chase is not permitted to extend credit, or that it should be required, in essence, to provide plaintiff with free vehicle. Look at that. They're telling you the response filed, despite plaintiff's motion being substantially and procedurally improper, meaning whatever she just said makes no sense and is not enforceable by law or the operation of law, points out that there's simply no plausible legal claim or argument that Chase is not permitted to extend credit. Meaning she's not saying that claim is not permitted to extend credit, or that it should be required. They're telling you, look into the National Bank Act, look into the National Bank Act, look into the National Bank Act. In essence, to provide plaintiff with a free vehicle, look into the principles of contract within the UCC. Accordingly, it is hereby ordered. Defendant J.P. Morgan Chase Bank, North America, N.A. motion to dismiss plaintiff complaint is granted. Plaintiff complaint is dismissed with prejudice. Meaning, don't bring this back here anymore. Plaintiff's Chamika Sanderford's motion for summary judgment is denied as moot, meaning it has no standing. The clerk should close this case, meaning get this crap out of our face. All of these might sound harsh, but it's the truth and reality of what's going on, and it's exactly how it's being dealt with. This is the reference to it that you're reading in black and white that you can cross-reference. These aren't my words. People, stop creating damage to yourself and the future. And stop creating a track record of trash that will make it difficult for other people. That will create a culture on the other end to make them comfortable to be tortfeasors. That will create ammunitions for them to throw at people. Stop doing that. We have to correct all the errors done in the past. All the trash that most people have been taught has to be revealed as such. And then we can get to point zero to begin to do things. That's the 9th one. This is the 10th one. Jones versus the United States. The docket number is civil case number 1:09CV56. United States District Court, the Western District. Showing you this case law after case law after case law. These judge-made law, which everybody says common law, that everyone loves so much that they really can't use or do anything with. People that love citing case laws, you will read some papers, 2 pages, case law citations, 3 pages, Black's Law citation, 4 pages, USC Code citations. Yet, somehow in the process of citing all these things, they fail to find or read this. All those things that they're citing, they don't even read on a comprehended substance. Because if they did, they wouldn't even put it on a piece of paper. On February 2010, the court entered an order pursuant to blah, 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 advising petitioner of his obligation to file a response to the motion for summary judgment, and explain the requirement that he present in his own evidence by affidavit or sworn declaration, which we went over. On March 22, 2010, petitioner filed a response to respondent's motion for summary judgment, which petitioner styled as an affidavit to order and notice, quote, an unrebutted affidavit stand as truth in commerce. See the same consistent pattern of buzzwords that people are going on and on and on about. There are worse stuff than this that cannot even be shown here because it's pure embarrassment if you were begin to show it. These that are being shown, heed these words. Know better, learn better. The least you can say is someone has not told you. Woe is the decision. In sum, for the reasons stated herein, the court must conclude that petitioner's claims are without merit, and the court will therefore grant summary judgment to respondent on petitioner's 2255 motion, which is the statutory aspect of habeas corpus, which most people don't even do right, because 2255 motions tell you, look, you should do a habeas corpus along with this. Most people don't do that. Finally, petitioner has not made a substantial showing of denial of constitutional right, meaning you haven't shown that we have jurisdiction to perform anything in your favor. A petitioner must demonstrate the reasonable jurist will find a district court's assessment of the constitutional claim debatable or wrong. The petitioner has failed to demonstrate both that court's dispositive procedural ruling are debatable, which is the order that he put in about an unrebutted affidavit stands as law, and that his motion to vacate state and debatable claim of the denial of constitutional right, meaning he has not proven the elements and test. As a result, the court declines to issue a certificate of applicability. It is therefore ordered that respondent's motion for summary judgment granted, meaning the people that he's petitioning against, they granted their motion. Petitioner's 2255 motion to vacate denied and dismissed. The court declines to issue a certificate of applicability, and so ordered. That's the 10th one. At this point, it's just getting repetitive. For the sake of time, we'll just stop here. You see several court cases, several jurisdictions, different time frames, an appeal level and on a trial court level, different circumstances. People bring in the same blanket stuff. You have to deal with the dynamics. You have to deal with the dynamics of the case, the dynamics of the type of right, the dynamics of the type of action, the dynamics of the type of law that you're bringing in. You cannot avoid it by just using some blanket term that sounds good you heard somewhere, that's unsubstantiated, that no proof of it is shown, no reference of it. A word is enough for the wise. This wildfire of misinformation about unrebutted affidavits stands as true has bit the dust also. Acceptance for value has bit the dust. Conditional acceptance has bit the dust. Unrebutted affidavit stands as truth and commerce, all that crap has bit the dust. Share this with people. People need to know about this, because misinformation is the biggest enemy that you and I face in today's world. Not the lack of information. In this world of information, there's a lot of information, so much so that you will be easily misinformed and misled. Someone somewhere along the line just wanted to make some quick money, spread the trash, took your monies, ran away with it, and left you with the misinformed zeal and passion that you're running around with. Or someone just wanted to sound cool, wanted to sound wise, and they said something and you ran with it. Or you read some PDF somewhere that somebody shared with you on some Facebook page, or someone said something that sounded real good and emotionally impulsive and stimulating somewhere, and you ran with it. You have to work the dynamics of the situation. Until next time, really, truly, best of luck. There's a reason why I always say this at the end of every video, because people need it. Best of luck.
Hey, and also don't forget to join my Patreon if you haven't. There I go through documents that I have used personally successfully and videos that I do not post here on YouTube that are in many ways private in nature. And also I go through live audio interactions and video interaction of my own experience with certain things. And I also have a website where you can go through a list of documents or services if you need them. And these videos that are posted on YouTube are also uploaded on Anchor. You can listen to it via audio means. And there's an Instagram page and a Facebook page. The link is on the screen and in the description. Take care and best of luck.